Good evening, everyone. Shriram, particularly the person who calls me over, and to everyone else. It's a great feeling to be back with you all. I think we started the coffee in the bar nearly some 4 weeks back, and everyone seems to have now understood so much more than how things were probably at the beginning. Today, we'll be doing a few slides on foreign judgments. And I thought I'll examine some of those practical aspects we feel confronted in our practice than being too bookish. With access to computers and software, it's always possible for us to key in on the necessary words and then pull out whatever we want. So, am I okay? Am I being heard all right?
Yes, sir, you're fine, sir.
So, therefore, I'll share my screen with you and we'll go through some of the slides, and that's the way I think we'll go understand this topic. Yeah, share. There I go. Then I begin with the slide. So from the beginning. Yeah. So the two large areas of foreign judgments. In that, the matrimonial issues of global Indians. What are we talking about? The global Indians. Indians who go out of India and get married, have children, or get married, don't have children, they have a problem. They come back and they leave some properties, and what problems they see. These are issues which keep coming, and I'm sure in your practice you must be confronting more such judgments than before. I just need to tell you one thing, that foreign judgments, you imagine Section 13 was made in 1908. What kind of foreign judgments could we have? Probably in all the transactions that we had with the UK and India, probably there could be some commercial transactions which could have given rise to some disputes, enforcement, or persons in Burma having some problems. They were still within British India, and so therefore I'm not even too sure whether it was considered foreign. To the extent to which Britain had a complete suzerainty, it was not foreign. But surprisingly for you, any case in India at that time, which was Mysore, for instance, Travancore, for instance, these were all are Hyderabad cases where there was there were kings, and they had their own systems of laws, and therefore judgments in Mysore were considered as foreign judgments in India and enforcement. And you had to come through Section 13 to understand and to what extent it could be enforced and when it cannot be enforced. So I want you to remember that at the time when the CPC in 1908 made references, they were not merely looking at foreign countries or what we see them as foreign now, but that is within our own the geographical limits, wherever there were independent kingdoms which did not come under the British suzerainty, and they were also considered as foreign judgments. Now, I thought I'll first let you know about the content of what we are going to be discussing. The first one, of what I will say, is I'll put them in three segments. One is the CPC provisions, and what is it based on? What is the normative principle which applies to understanding foreign judgments? And the same way as what Section 13 makes it, also 46 of the Arbitration and Conciliation Act takes it, when it can be opposed. It's in a negative format of what you'll find in Section 13. When can it not be applied? That's what you'll find in Section 13 and 46 of the Arbitration and Conciliation Act. And then there is some private international law concepts which we must know, because the Section 13 does not give you an idea. What do we understand by private international law? It is also called as conflict of laws, and therefore we need to know something about it. And that is what will be the second segment. And the third one, this can be a very big topic by itself, the matrimonial issues of what we could confront with the foreign judgments. There is something very unusual about the matrimonial cases. One with reference to custody of children and another with reference to dissolution of marriages. In foreign judgments, we will see situations where there could be simultaneously two lines of cases going for the same subject matter. Here in India, it may not be possible when Section 10 would help you secure a stay of the proceedings if there is a proceeding elsewhere in another country, in your own court, in some other court, between the same parties where there is likely to be some congruity of issues. We'll be able to stay things. There will not be another case. But for the same relief, it will be still possible. CPC itself makes it possible for us. That also we'll see with reference to matrimonial issues in particular. And therefore, the first part of it, the CPC provisions, will just run through some of those provisions, which anyone can access to know. There is nothing extraordinary. But I thought how the language is made, you will see, a foreign judgment shall be conclusive as to any matter, thereby directly adjudicated upon between the same parties or between parties under whom any of them will claim. To this extent, you will find section res judicata, between the same parties or any persons from whom they claim. They will be bound, obviously. And now, what is it that makes this different? It will be for a foreign, there must be a foreign element. And they will not be bound. Then there are exceptions, they said, where it has not been pronounced by a court of competent jurisdiction. Therefore, you will find, if you need to understand when it can be enforced, you'll put a negative for each one of this, A, B, C, D, E, F, where it has not been pronounced by a court of competent jurisdiction. No, it will not be binding. So you must see and ensure that the court which has passed that order, which is sought to be enforced here, or which is sought to be stated in defense as binding on parties, it is passed by a court of competent jurisdiction. Where it has not been given on the merits of the case. What do we understand by the merits of the case? Supposing a person secures an ex parte order, a decree elsewhere, or a person does not go and enter into a big contest, admits himself to certain costs. Would that mean entering a decision, adjudication on merits? That's what you will see. Then whether it appears in the face of the proceeding to be founded on an incorrect view of international law. If you are ever wondering whether a foreign court could have passed an order or a decree on an incorrect understanding, you must know it is all possible. In any country, you can be misled. You could be doing something of what, because there have been judgments like that as to what is incorrect view. A court has passed an order or a decree which cannot be accepted at all, which will not stand judicial scrutiny elsewhere. And that is that. Where the proceedings in which the judgment is obtained are opposed to natural justice. This happens in situations where you find the normal understanding of the administrative law principles of natural justice. Ordi alterum pactum is the most important element. Then your order has to be reasoned order. There is a quasi-judicial function. It has to be well reasoned. And then the person must have had an occasion to be served. There was before a person was called to appear, that had been served. All these will be the things which all of us understand through administrative law. We understand principles of natural justice. If there is a judgment which is rendered which is against those principles, or where it has been obtained by fraud. Now, fraud can be intrinsic fraud, extrinsic fraud, where a person is prevented from coming. So these are illustrations where it sustains a claim founded on a breach of any law in force in India. So where it is opposed to public policy, what the Indian government will not approve of, and it is opposed to that kind of a public policy, and it seeks for an enforcement here in India. What would not have been possible here for an enforcement if a decree had been passed here, or if the decree itself could not have been passed because it is violative of some principles of public policy, then what may not be there elsewhere, if there is an order or an award, it cannot still be enforced. So therefore, it is in some kind of negative form. You look into this. CPC contains, again, in an explanation, a huge understanding. The section 10, I already said, was stay of proceedings is section 10. Pendency of a suit in a foreign court does not preclude the courts in India from trying a suit founded on the same cause of action. You will find, therefore, this happens in matrimonial jurisdictions. There will be a decree or there will be a suit which is filed for dissolution of marriage in a foreign country. You will find the same person or the opposite party, instead of defending the action, he or she would have filed a case here in India for the same relief or against that relief. So these kind of things happen, and nobody can say now, why did you go to India to file a case? It may not be possible. Or the other court, the other country may not be able to say that country has no business to go on with that case. It may not be able to say. So therefore, it is merely declaring an obvious principle of nation's sovereignty, their entitlement to have a judicial system set in place, and the rule of law which empowers parties to approach court and secure justice the way they think it is appropriate. So therefore, that also is one which has a foreign element. When Section 10 explanation contains that. And Section 44A, it says execution of decrees passed by courts in reciprocating territory. This happens, have you not seen? There is a prime minister or a president or somebody coming, they shake hands, and there is already a big diplomatic team which is working. Then they sign papers, they hand over. They enter into contracts on several things. How commercial transactions must go easily, how some tariff you will give some concessions, how you will provide for exemption for some taxation. So many things happen at the time of mutual agreements between two countries. And they may also say, in many situations, they will say, judgments of your country will have immediate application for us. This kind of contractual is a kind of a treaty and an understanding at diplomatic level keeps taking place at all times. And therefore, where there is a reciprocating territory, or what we mean is, it's another country has in friendly relations with this country, say, that our judgments, our decisions, our courts will have a right to decide on things, you will give enforcement, something like that. An execution of a decrees outside India, how does, where there is a decree in relation to parties where an execution is filed elsewhere, how will it find enforcement? This is what is contained. These are some of the provisions of what you'll find in the Civil Procedure Code. But substantive law of what it is, we'll confront the foreign judgments some way like this. I may not have given an exhaustive list, but I suppose these we see succession issues and intestacy, or through wills of persons domiciled out of India, owning properties, I've said owning properties, movable and immovable in India. So therefore, there must be some element. Both parties living outside India, they leave some property here in India. Both of them, one of them lives in foreign country, leaves a property there, and he comes to India, he dies. Or yet another person who is here in India, who is an heir at law to the person in the foreign country. So therefore, we'll have, in all cases of succession where somebody leaves some properties elsewhere, movable properties outside, some of the decisions of what we'll see, we'll notice they have immense relevance. Incidentally, we have also a UN Convention on International Bills. International bills are somewhere similar to the bills of what you have under Section 63 of the Indian Succession Act. It contemplates a similar state of execution, attestation by two persons at least, a person of, and it is possible for you to make a will and enforce, have the legal heirs or the beneficiaries under the will to secure the bequest which is taking place through the will, if it conforms to certain standards. Or what we find in Section 63 is kind of a universal application, or what you find with two persons at least. In the Code Civil, there were larger number of witnesses. There were 4 witnesses there, and the wills were there in the continental jurisprudence. You don't need to prove anything more. Unlike the Indian Evidence Act, which talks about a denial, and if it's a will, you'll have to prove it at all times. And there has to be a denial. A person always proves the will who propounds it. The continental jurisprudence, you have a will, then it is immediately enforceable. That's all. If anyone thinks that will is not correct, he has to file a suit and then set it aside. So there are different concepts, and they have been put to practice till very recently from Pondicherry. Some of those persons who have had experience in dealing with cases from Pondicherry, there was the element, the foreign element in Pondicherry of those wills. The Indian Succession Act itself was made applicable only in the year 1969. So prior to that, all wills there, they were all treated as foreign wills, and the Code Civil was applicable The manner of execution of bills was different. The manner of understanding and enforcement of the bill was different. And now in Goa, you still have the situation. It's the Code Civil which is still applicable. I'm not too sure whether the Indian Succession Act has been applied there, but there have been decisions about that, about how Goa carries some of those colonial past still in the practice. And then commercial disputes resulting in decrees in foreign countries through adjudication courts. I'll also add there all kind of situations where you'll find some contract where one of the parties in a foreign country secures an award, a decree that can result in foreign judgments. Admiralty jurisdiction. This again is probably one area wherever you are practicing, you will confront foreign judgments in large number of cases. And practitioners of tax law will know in the manner of contract between countries when they secure to themselves some double taxation avoidance agreements, where you have the principal enterprises which are here, whether they can have the benefit of tax avoidance or not, will be considered foreign judgments to that extent. Again, the outsourcing of work in India. What happens in a foreigner secures some work here and gets all those work which is done here, goes back there to that foreign country. And whether that income of what the foreign country makes through these contracts and these work which is done, for instance, some software development which is put in practice there, no activity is done here at all for them. The business activity is elsewhere, and they have the work, there's some work outsourced here. The Indian company makes profit. The foreign company also makes profit out of the work which they are doing. Will they be liable to tax? And could that be done? So this kind of inter-country issues could result in some decrees being obtained in either of those countries. And therefore, here again, to those situations also will see some application foreign judgments. Inter-country cross-border arbitral awards, section 44, 46. These are issues, like I said, 46 has a language similar to how you have in section 13. All these things will be done except when. So therefore, that is how it is framed. So you'll have a look at that. And then if you have read that, I'm not going to be taking you through that. I'm merely flagging some areas where foreign judgments will be there. Cross-border mediation, and now this has happened recently in 2019 in August. India was one of the signatories. We have also signed a document where United Nations they have introduced a convention to which 46 countries signed, including India. And the idea was that if there is a mediated settlement in any part of these signatories of these countries which have been signatories, they'll be immediately enforceable as if it were an award. We are familiar with what is there available under Arbitration and Conciliation Act. If there is an arbitral award in any foreign country, to which we have under section 44, when foreign awards can be enforced, you have 44, 46. Similar thing was there also for conciliation. If there is under conciliation, there is always that foreign element which is likely to be there, and that can also be brought. Now, mediation now, if you see conciliation as merely some aspect of mediation, now they want to make all the signatories have a standalone legislation which will make possible for the enforcement of the mediated settlements outside the country to be enforced. Any of these cross-border mediation, when they take place, it can be enforced in India. They make an exception to succession, it will not apply. They say matrimonial matters, it will not apply. So it's essentially commercial issues which they're thinking of. But right now, India has not made a legislation. I'm a part of a committee tasked with framing a legislation for mediation. We are still at the job. We are not able to conclude it. But the Supreme Court has been monitoring our activities. Probably we'll be able to give in a document as soon as this COVID situation makes possible exchange of information of what we have. So it's an idea what it is about, what can happen in future. Right now, cross-border mediation cannot take place here. You won't be able to enforce any award, any settlement which is taking place outside India. Even within India, if there is a settlement, unless it is the court annexed mediation where a case is referred, already there is a case and then it is referred for mediation could work. Otherwise, you need to draft it as if it were a conciliated matter, and then you can secure the status of an award for enforcement. Matrimonial settlements, this is again a key area of importance, where matrimonial settlements are when the parties decide to dissolve the marriage or they decide to stay away from each other. And what is the kind of distribution of assets which will take place? In India, under the Hindu Marriage Act, if you are looking at a provision to which large sections of people are governed, or under the Special Marriage Act, you have provisions such as the Hindu Marriage Act, you have section 27, only gifts made at the time of matrimony or where a property is purchased jointly by husband and wife, they get to be divided. There is no law which makes possible for you to pull in all your independent resources and assets and then divide the property, which is what is prevalent in many foreign jurisdictions. Matrimonial settlements are key issues. Just a matter of aside, Bezos, who is the Amazon, the person who runs the show, his wife, there was a dissolution and the matrimonial settlement resulted in half of his assets to go to her. She is incidentally the world's 4th richest person now, even after the dissolution. That is the kind of, there is a matrimonial dissolution there in foreign jurisdictions, it can rip a person if he or she has assets, amassed wealth, and there is a matrimonial settlement, parting with the assets could go in a big way. It doesn't happen in our jurisdiction, but still where there is a foreign element involved, there could be a matter of division of all assets, including the assets within India. And that is something which we'll note as important to us. Some of the leading decisions I thought I'll give to you, which will give you an idea about the huge canvas we are drawing on. These decisions relate to how we understand the foreign judgments. Vishwanathan versus Rukunul Mulk Syed Abdul Wajid, 1963 Supreme Court 1. This judgment was interesting in so many ways, because when you see Vishwanathan, this is a case with reference to a property in one Ramalingam Mudaliar in Hyderabad, in Bangalore, who had contracts, who made substantial properties. He had assets in Mysore state at the time, not within the British jurisprudence, British suzerainty. And you had assets there, and he had also assets in some property in a big sugar factory. He had established a sugar factory. He had made a will, and the sugar factory was in Bellary, which was in the Madras presidency. So you had section 13 applied, and they said something significant in that in Supreme Court. They said the rule of conclusiveness, what you are accustomed to or knowing under rule of res judicata, between same parties, a previous judgment, it will be binding. This is what you understand through 11, isn't it? But it is not the same thing when we are talking about foreign judgments. I already told you, section 10 explanation makes possible with reference to same subject matter, there could be yet another suit, because two independent states, two independent countries of suzerainty with the sovereignty of what they have, it is possible for you to allow for decisions, allow for access to justice in their own respective jurisdictions. And therefore, it's an important pronouncement which the Supreme Court makes when they point out to the distinction. What you understand in the rule of res judicata of a previous judgment between the same parties, that will not be understood the same way is what Vishwanathan said. In Vishwanathan's case, if you look in 1963 Supreme Court, for me it was fascination. I realized it's probably some of the Monteith Road and Wallace Road and the Palm Grove, the Hotel Palm Grove, it seems like it was Vishwanathan's estate. So therefore, they seemed interesting to know how these assets were dealt with, how, and this Vishwanathan's case also was significant for something else. Among other things, whether a foreign judgment will be valid, whether it is vitiated by natural justice. Section 13, they were looking at a situation where the point was the judge, the Mysore High Court judge was reported to have traveled in the Mercedes Benz of Vishwanathan. So mind you guys, if you have some aspirations to be a judge sometime, be mindful about the car you're traveling and who is supplying the car. Later, if there is a case before you, there could be a point which is stated, this person is biased because this is how you travel. All this could be important, what Vishwanathan's case talks about. And Badal and Co. versus East India, 1964, it talks about a foreign award, or how it can be enforced. What is, at the time, before 1996 enactment, they were governed by different conventions. We have directly there now under section 44, 46, we understand what is done. Just to let you know that even before foreign awards, arbitral awards were capable of being enforced, was what this judgment brings about. Sankaran Govindan versus Lakshmi Bharati, 1975. The Sankaran Govindan is in some sense an issue relating to succession of movables. This was a person in UK leaving behind some movables. Whether in respect to those movables, what will be the law? Whether an award which is, whether a decree which is passed there in UK, can it have any value in India? Was what they were seeing, and they said, in respect of movables, a person who is domiciled in a particular country, he is entitled to make any disposition. The rule of succession will depend on where he is domiciled. He was in UK, and therefore it will be the UK law which will be applicable. They were trying to prove there in that case that this Sankaran Govindan's case, that estate, that person was preparing to come to India. He had at all times wanted to come to India. Will this person still be bound by a foreign law of the assets which he had in a foreign country? They said yes, because they were applying a rule of private international law, saying that for movable properties, it shall be the domicile which will be relevant. And so now and then you have some halo effect for me. There is a light there through the window. Allow that kind of a thing to go for some time. It will go off within a short while. Allow that. Sankaran Govindan therefore brings you issue of domicile, where a person has an intention to live, and what is the law which will be applicable, whether it is foreign country or this country. Alcon Electronics Silem versus SCA France. This is a recent judgment where Justice Ramana has to say implementation of foreign judgments in territorial countries, and this is a patent case, infringement of a patent issue, and the point which was taken was whether it was, they were saying under section 13B of the Civil Procedure Code, is it a case which was rendered on merits? They said it was a case rendered on merits because one of the parties submitted to jurisdiction in a foreign country, no matter he did not contest in the full-fledged manner and secure a judgment on a full-fledged contest. What he did was, he was there joining issues on a very simple point. What will be the cost which is incurred? Will I be liable for cost? This is the only issue which was left open there. And therefore they said that this will be seen. And that judgment will, by a foreign judgment in UK, will bind this person because he has submitted to jurisdiction. Therefore it must be taken as a decision on merits, is what they said. Narasimha Rao versus Venkatalakshmi. This is an important decision. For the court was wrenching its hand and says and was saying, we still look to British jurisprudence for understanding of so many concepts. We are still thinking that if we must understand their rules of private international law alone will apply, we need to make several principles applicable even in India. So that is not already happening, is what the concern was. But this was a case where there was of two parties, British citizens they were, and both of them had a matrimonial dispute where there was a decree for divorce. The man, after obtaining a divorce decree, got married again, and there was a woman who had come to India who was trying to say this marriage is not valid. She was taking action under the IPC for bigamy against that person. Will the foreign judgment, a decree for divorce which is obtained in a foreign country, will that be valid? Will it be enforceable? Did he marry the second time? If he had married, will that marriage be valid? Will she have a right of action for bigamy against her husband? All these are brought in there, and they found it was a case of fraud for the fact revealed that these persons had married in Tirupati. The Narasimha Rao Venkatalakshmi had married in Tirupati, and the husband had gone to Louisiana for a short period of about two weeks, 2 months. Filed an application there, got a decree for divorce. The wife was served, but she still couldn't go. Could she have gone there to contest the case? Was that court which filed the case, which entertained the case, did it have jurisdiction? They were all issues which were taken. And they said, now he was merely residing for a short period only to found a jurisdiction. It was an instance of fraud. So they were applying under section 13, case of fraud. Therefore, it will not be valid, is what they were saying. So this is some of the expressions of what you find in section 13, they're taken up. Now, one of the important rulings on Admiralty Jurisdiction versus Kamar, MEAI Kamar versus Savalaris Salvage International, that was in 2000, where this was a case which was instituted in a foreign country, in UK. And by the time an enforcement of the award was, enforcement of the decree was sought to be done against the owner of a ship for some goods which were in the ship. The ship had sailed to India and docked in Visakhapatnam. The issue was whether the decree could be enforced there in district court in Visakhapatnam. And the contention taken was this was a decree which was passed in UK without any validity. It didn't have a jurisdiction. And the court was looking at the Committee of Nations as a prevailing thing. And they were also saying that this is a reciprocating country with UK. We have all decrees which will have to be enforced in India as well. And important thing, more than that, is section 44A. 44A must be seen as an independent section, which gives a new cause to enforce it directly. It's as if a decree is passed. You won't be able to, the same way as what we say, at the executing court, you won't be able to challenge the decree itself, unless it's an issue relating to complete lack of jurisdiction. Otherwise, you'll have to simply enforce it. The executing court does not say anything. They're saying when the execution was sought in Visakhapatnam, nothing else will be seen. It just will be seen as a completely an independent provision which enables a party to execute it, and the execution will be with reference to a decree which has been obtained in a foreign country perfectly within reciprocating countries. It will be binding, is what they say. So these some of the leading subjects which give you a complete expansive understanding to various provisions under the CPC through these decisions. And the conflict of law is the second segment which I said I will address, because we will, many of the decrees which get to be passed to understand what is it that we understand through these principles. There are either common law principles or statutory provisions recognize some of the principles which are enunciated through the private international law. One of the prime considerations with reference to common law principle is it's a Committee of Nations is more an issue of deference and not an obligation. This is an expression would seem like some quibble with some semantics, but it's not. It is a court which gives deference to yet another court. And that is why I'm not obliged to do that. I'm not obligated to do that, but I think that's a court which is a court of jurisdiction, which is competence. And section 13 says if it is not any of those things of exceptions, I will give enforcement to that. That is a common law principle which is founded through judicial pronouncements in UK and which we follow. And then persons are governed by two systems of law, and there is a foreign element, either by one of the parties being a foreigner or property situated in a foreign country where a contract was entered in a foreign country. So this is a principle. If you're talking about private international law or conflict of laws, we are talking about all situations where there is some foreign element. One of them must be in a foreign country. One of them must left behind some property in a foreign country. Therefore, a contract must have been in a foreign country. An enforcement is sought to be done in a foreign country. So both parties in a foreign country, if husband and wife marry in USA, Indian citizens go to USA, acquire citizenship there, they marry there, and they have some property dispute. It can't be in Indian law. We, both of us, will decide that Indian law will be applicable. You don't have a choice of law there at all. So therefore, if only there is a foreign element of one of them being in India, or a property in India, an enforcement in India, that is a principle again which is being enunciated over a period of time. And of these principles, there are two references to which law will govern. You will find probably under the Arbitration Conciliation Act, when section 20 says the seat of arbitral jurisdiction. Now, parties may decide what shall be the seat. And one of the judgments recently of the Supreme Court in 2017 by Justice Rohinton Nariman was, unlike in CPC where you cannot invest a jurisdiction merely by the will of parties, in arbitration it is possible for parties to invest jurisdiction. You can, you and I can be in Chennai, and we can enter into a contract, and an arbitral award arbitration clause may say, in case of any dispute between parties, it will be done by an arbitrator in Bombay. It is possible. So this kind of a thing is possible. What is contractually is possible with reference to private law principles, private international law principles. If there is a property, immovable property is the lex loci principle. That is, when you're leaving behind a property in USA, the law which is with reference to recognition of persons who are the legal heirs in USA will govern. If it's movable property, domicile, I already referred to a case in domicile issue. There was in Vishwanathan's case was a case of domicile, and they were saying, not the Sankara Kaundan was a case of domicile, and wherever the properties are situated is one. Domicile is for movable properties where a person intended to live, something more than mere residence, not a person who is in a contract for say TCS or something. He goes there for a short period. He is there in UK or USA for some time. He may have in his mind some secret thinking of staying back there in USA, breach the contract and stay back there. But then he is gone on a contract. He leaves behind something. She leaves behind something, and she dies. It's a both with reference to merely because she resides there in USA she does not become domiciled in USA. It's a simple principle, isn't it? It's just that we need to know that it exists. And then some of those principles of conflict of international law or private international law are brought out through our constitution and to our provisions, statutory provisions themselves. These are things which are essential for us to understand how come a decree is passed in a foreign country with reference to property in India. Could there be a decree? In which case, in order that you test whether it is a case of competent jurisdiction, you'll be applying the principles of international law. So therefore, when I'm taking you beyond CPC, the idea was in what situations we'll be able to see that that decree is valid. Will you be able to test the correctness of jurisdiction exercised? What will you do? All those principles are available only through this. And some constitution provisions under, say, 245 clause 2, extraterritorial applicability. You will know section 3 and section 4 of the Indian Penal Code. If a person goes to Uganda, murders a person, he comes to India. For a person murdered was in Uganda, could he be tried here? It is possible. So therefore, an Indian, you go and do things, extraterritorial application is there provided in section 3 and 4 of the Indian Penal Code. So therefore, where do you see that power? Though it is a pre-constitution imperial legislation, Indian Penal Code, you still have the validity of the law. Where do you see that? It is done under Article 245(2), which says that it is possible for us to lay down a law and say that even beyond Indian shores, something has happened, it can still give a cause of action in India to enforce. For instance, two persons go out of India, Indian citizens go to a foreign country, get married in a foreign country, have the marriage registered in a foreign country. They may have some properties here, they may have some Indian interest here, and they could still be bound with reference to some maintenance. If one of them comes back to India and she applies for maintenance here, will it be possible? As a court, can it enforce it? Can Hindu Marriage Act could still be applied? Hindu Marriage Act will still be applicable in respect of foreign Indians if they are Hindus, where they are domiciled at the time when a case is made here. So there you have, where is the validity for such a provision? You will find under Article 245, that is the principle which makes it possible for you to do. And then Indian Succession Act itself, all the definition of domicile with reference to probate which is obtained in a foreign country, you come back to India, and then say with the probate obtained in a foreign country, there are also assets in India. You can simply produce under Section 246 of the Indian Succession Act, secure a letter of administration on the basis of the probate which is obtained in a foreign country. So these are possible for you to do, and these are application of principles of private international law through legislation itself. You know, I said with marriage laws under Section 2 of the Hindu Marriage Act, what is necessary is domicile. A person is, both parties are Hindus. If they are there, no matter where the cause of action has arisen, supposing the wife has been abandoned in USA, the marriage has been in USA, they last lived together in USA, she comes to India, whether Hindu Marriage Act will be applicable, it will be applicable under those provisions. It's possible that it's also a foreign jurisdiction, foreign law could be applied because they were domiciled there for a long time. But then the moment she comes here, she intends to be here in India. She can't come here, file a case and go back. But then law requires in Section 2 domicile, that to that extent it will be applicable. So these are some of the principles in order to understand how a judgment could be tested as valid or not. It will be the principles which will put them through for your understanding. And, this will be the last segment of what I said I will do. The matrimonial issues can come in these ways. What are the ways do I see? Divorce decree by a foreign court, parties married in India, governed by Hindu Marriage Act. When is it still not valid? That is what they were considering. They were not finding it valid because a false jurisdiction had been created in for parties who were last living in Missouri. He had gone to Louisiana and then filed a suit, obtained a decree for divorce, and that decree is not valid. That decree was there independently of that. The wife had come here to India and she had filed a case. That decree will not be valid. The husband can still be proceeded against, but bigamy, what the Supreme Court was saying. So this again, matrimonial things, how a person is, where you commit a fraud, it need not be, you don't need to file a suit to declare something as brought by fraud. The same way as in our Indian jurisprudence, fraud can be pleaded even in defense, isn't it? It's possible for you to say without being in any way limited by the law of limitation. Law of limitation would require you to set aside a transaction if it's fraud within a period of 3 years. But in defense, you still have a scope for you to say it is possible for you to say it is not valid. So that is possible. And then Indian law does not recognize irretrievable breakdown of marriage. It's possible only under Article 142, the Supreme Court saying that the marriage is broken down. And in a judgment which the Supreme Court has laid down, it says it is possible for us to declare a marriage is broken down and decree to be granted. But no other court in India, not even that 6-month period has to be gone through. And that has been stated like that. In a foreign country, supposing there is a divorce made, sometime recently somebody approached me and asked me, and this is about a husband and wife who have gone from India, who settled in USA, they are married, and divorce has been granted on the ground of irretrievable breakdown of marriage. In many foreign jurisdictions now, theory of fault, ground of fault is not necessary. In India, fault is a necessary ingredient in order to be established for you. Unless you're talking about dissolution of marriage by consent, any other dissolution has to have any of the grounds which are mentioned there. Under the Divorce Act, under the Shariat, of course, it doesn't have any ground to be given. But even then, there must be an attempt. Triple talaq is not valid anymore, is what the Supreme Court has said in Sharia Banu versus Union India in 2017, 9 SEC page 1. This is again an interesting judgment for how the judgment went to 3:2, and with Kehar, the Chief Justice at the time, with another judge, they were striking a dissent, and the majority said the law was the triple talaq was bad. But for us to know how they become relevant, all around, to take Shariat for instance, all around India, Pakistan, for instance, does not recognize such a talaq. Many of those countries have not recognized. So therefore, it'll still be possible for you when somebody is now trying to secure a divorce here or dissolve a marriage. It'll be tested on what was there in the country where they lived together. What is the law which was there? And was it possible? Not possible? Is this law understandable? But irretrievable breakdown of marriage, if a foreign country grants a decree like that, it will still be valid if both parties are there at that time, secured a divorce in the way in which the law provided. There is nothing inherently impossible under Section 13 that whatever ground was necessary to validate a decree here need not also exist in a foreign country. In a foreign country, there could be some other grounds which could be available, but you'll have to still see whether it is affected by any of those exceptions from A to G, which Section 13 talks about. Similar provision like what you have in Section 46. And the same way for matrimonial conflicts, I just thought in all these cases, parties elsewhere, married, dissolution done, all that our marriage law requires is persons must be domiciled. Special Marriage Act, where Christians or one of the party where they marry under Special Marriage Act, the divorce provisions require domicile as an important ingredient. Hindu Marriage Act Section 2 talks about domicile, and Divorce Act also makes domicile as a necessary consideration. Matrimonial jurisdiction is governed through the law of domicile. This is again a principle of private international law, which we are applying through a legislative provision. And marriage settlements, I said, of how splitting the proceeds, splitting the assets, pooling the assets and dividing. In India, it is not possible. Pooling the assets and then dividing is not what is contemplated in Section 27. Not even the Special Marriage Act or the Shariat declares that. Shariat only talks about Shamim Mara. The Shamim Mara, there's a clever interpretation by the Chief Justice at the time, Rajendra Babu, where he said it is not during the period of Idda alone the maintenance to be granted. That was what you understood by the infamous legislation that came after the Sharabanu, where the Supreme Court went on to define it and say that what must be paid during the period of Idda. The entire maintenance of what could sustain her for the whole life is what they said. So therefore, you will find that the marriage settlements of what Indian law provide for will be grossly inadequate in comparison to decrees elsewhere. But all those decrees could still be enforced in India if it's a valid decree which is outside India. So the point which I was trying to make for you and for you to understand is it need not be tested whether such a law could have been passed, if such a decree could have been passed on the ground which it has been passed outside. That need not go through the test at all. And this is the last thing which I would like to take, and then we'll take the field for questions for you. And the child custody issues, there has never been so much of uncertainty as what you see now in the way the law is developed. For a long time, in any matrimonial dispute between the husband and wife, the subject of dispute itself could be the child. It's almost seen as a kind of a blackmailing point. They may have the disputes on so many other issues, because of so many other issues, but they will make the child as the fulcral point on which the whole dispute could revolve. They may seek for bargaining positions on the basis of who holds the custody of the child, who is entitled to primacy of custody. Here, somewhere the parties in their fight, the child becomes a pawn. And there's a lovely judgment of a Madras High Court with reference to how Khalil Brand's poetry, how the child is taken as the pawn, but it is not really the child. Child is the, it is because of the child you exist. It's not that because of you the child existed. The child is there and therefore you are. It's a beautiful poetry, and that is also quoted there in the judgment, and gives you an idea about how people fight and make the child as a scapegoat in the fight. The best interest of a child never comes anywhere. The best interest of a child comes for the first time. Before I started, I was speaking to Shriram. And Sriram was saying about the children and things who will be competent. I was merely discussing about how this law by itself is such a huge area of dispute across, and it could probably be the subject of future because unfortunately marriages are not as stable as they were before. We have again persons going from one country to another, then coming back to this country and fighting a litigation from in India to a foreign country. And a child is brought, abducted and taken. And this child abduction, it came through United UN Convention, Hague Convention on Civil Aspects of International Child Abduction. Unfortunately, India is not a party signatory to that convention. And therefore, if a child is abducted from UK to India, USA to India, France to India, if there is a decree already passed, this convention, Hague Convention, says that decree of what is passed already in a foreign country will be applicable and you'll have to enforce it. But not, India can't, India has been holding it very close to its heart, and it says it will not sign in the convention because it does not want to see those aspects of what govern the foreign jurisdictions also for India. We want to keep that law distinct for us. We have in one legislation, this Juvenile Justice Act of 2015, Juvenile Justice Act 2015, care and protection, that expression you have under 215 law. For the first time, you have section 2, clause 9, defining best interest of a child. You didn't have it before. In no legislation you have. There is no other legislation in India which talks about best interest of a child. You don't have it under Guardian and Wards Act. You don't have it under the Adoption and Maintenance. You don't have it under any other provision where a child's interest could be there. It is available there in the Juvenile Justice Act. Section 2, clause 9 defines the best interest of a child, means the basis for any decision regarding the child to ensure fulfillment of the child's basic rights and needs, identity, social well-being, physical, emotional, intellectual development. Look at the comprehensive definition of what this comes through international conventions. And we have, therefore, Juvenile Justice Act has two independent, two areas where a child which is in conflict with law, that is Juvenile Justice Act. For a long time, that is how JJ Act we had in our mind. Any child which is in conflict with law, any minor in conflict with law, where you will go to JJ Act. Now, care and custody, all those things come under the JJ Act. Importantly, among other things, even adoption, a secular adoption which is possible for a Hindu or a Muslim or anyone to take a child. For Muslim, otherwise Sharia did not permit. Christian law also did not originally understand. But we have very interesting interpretations of that coming through Madras High Court in Bombay, how the JJ Act 2015 law makes possible this kind of adoption, they said. And Guardian and Wards Act makes a reference about the welfare of the child. And each one of these issues, they bring out some concepts we need to know. Committee of Nations, the judgment to which the Supreme Court, Justice Thakur, I will make reference to some judge's name also now and then. It's only because there is a certain charm in certain. If I'm seeing the senior Chandrachud's judgment, I'll feel impressed by the lucidity of the language. Vivian Bose for the sheer flair of the language. Krishna of some expressions of justice, social justice in ways which he said. And therefore, here Thakur was a Chief Justice under whom I had occasion to work in Punjab, a very amiable person, and he writes with a lot of emotion there. Ruchi Maju was Sanjeev. I said Ruchi Maju, it's a Ruchi Maju. Gives about the importance of Committee of Nations. Each one of the judgments, rule of first strike, this again you will find, this comes in Suryavardhanan versus Tamil Nadu. It came through our decision, Madras High Court decision was set aside in Supreme Court. And Justice Lokur, Madan Lokur also had a lot of interesting judgments about prison rights, children particularly. He has penned important decisions. One such judgment to Suryavardhanan. Suryavardhanan, he says now, rule of first strike, he was making a reference about a case where parties were husband and wife married in USA. And in that judgment, Suryavardhanan case, they were British citizens. The father had sought for custody. The wife had come to India. She had applied for dissolution of marriage. Father had sought for custody in USA. She had come to India. Actually, when the wife was coming, she had come from UK. Both of them were British citizens of Indian origin. They had a child. Child was of British citizenship, and she had come here and kept the child, admitted the child somewhere here in Coimbatore, and she filed a petition for the husband for some maintenance and other things, and she had filed a suit for injunction and secured that the child cannot be taken away. He had, even before that injunction, he had filed a petition, and the UK court had directed the child's custody to be handed over to the father. And Justice Loku said the wife did not ask for any custody or anything for 2 years after she came to India. And he has made the first strike of securing seeking for a relief in a foreign country. That rule of first strike must therefore be to recognize that entitlement for that person. That is rule. And inapplicability of foreign convenience. We know in Bhopal Rajari case, among other things, our Attorney General went to USA to say Indian laws are not effective. But then the Supreme Court, KANNAN, did not take it. He said the forum convenience is India, so multitude of persons, enormous number of persons, a poor segment who have died or suffered deprivations, they'll all go back to India. That is a forum convenience. But for matrimonial issues, forum convenience, surprisingly, is not relevant at all. It will be the complete principles otherwise of the welfare considerations of what will govern. Best interest of a child, like I said, now we have some tests. When you have a case coming, because it's a temptation for you to believe that it's possible here, law makes it possible for you to file a case here, there is a case there. What is wrong? In Lakari Sakmari Shoban Kadali, look at the name, I'm not able to get it correctly. 2019, this is a recent judgment of Kanvilkar, where in this judgment, the marriage took place in Hyderabad. They went to US. The children were also US. The wife filed a petition for divorce in 2016 there in US. Came to India, had the child along with her, and she had approached the family court, obtained an order of injunction in the family court. Now look at this. She was the person who had filed the case here. She had filed the case there. She had come here to India. She had sought for an injunction. She was in that context a person who had made the first strike. But they were not applying the rule of first strike of what Lokur said. In Lakari, he said, now look at what the child is doing. The child is a foreigner. For these two children, one was born in the year 2012, another in the year 2014. They must be there. And you have come away here. You go to USA to do this case. The husband will also provide maintenance or will provide for litigation expenses, air charges and things. And they were not prepared to recognize the rule of first strike, but still were looking at it from the child's point of view. The best interest of the child was the predominant consideration. Nityanand Raghavan versus NCT in 2017 was, they were staying in India. The husband had been in foreign country, and what would be the effect? This again, they handed over the litigation to go only in US and did not say that India must have, the Indian court must have the jurisdiction. But in all these cases, you have at various times, various principles applied. Foreign convenience, one time irrelevant, and court of intimate contact, which is a court which has intimate contact. They said this will be decided on which court is easily, it's not in the issue of accessibility, but the court which has exercised jurisdiction and effectively can bring about its orders and enforcements. So this is how these point was seen. And there are other subjects also which are mighty important. Inter-country adoptions are issues where two countries having different laws and what can happen. And the inter-country adoption issues have been very difficult. It all came through Lakshmikant Pandey decision and the later decisions of several directions which are given. Now there is an institution, KARA, which governs, which looks after these issues of what is possible. We have a bill, there's not yet made a law. Several confusions in, there are judgments of the Supreme Court where we don't know what to do, where two persons from Germany come to India. They have hired the womb of a person for impregnation. The child is born, the child is abandoned and gone. And the mother, the biological mother, is entered as the mother of the child. Father, the person who donated the semen, the German person was recorded as the father. So the German wife, she was aghast that the child belongs to us, between us. There is no difference between us. There is no, we don't have any differences. How do we have a mother, an Indian mother, and a foreign father? It can't be there in a document. Our court didn't know what to do, and they merely allowed for the children to go. The Bala's twins case in Supreme Court. There's several confusion there. It's not settled because there is no legislation there. Surrogacy arrangements and issues of what can take place through where a Japanese couple had a surrogacy agreement. They had a child. They went back to Japan, and the husband and wife, they separated. So the husband alone came to India along with his mother, said, we want the child. They said, no, you have not entered into an agreement. Where is your wife? The man said, no, I've divorced from my wife. How do you hand over the child to the grandmother there at the time? This was again some issue. There is no clear understanding of the law. But in Japan, surrogacy is not recognized. We merely dispatch the children with some kind of a passport, and for that country to see whether it could be recognized or not. He could only be granted guardianship. He couldn't have been taken as a father. What has happened to the child and the status, we don't know. So there are issues in child custody. We must remember this, that best interest of child, of what we see, is what will govern our understanding. And who has the first strike is not a final position. And which is foreign convenience is not again the last thing. So these are kind of, I've come to the end of it. I have no more slides to show. These are the broad issues of what would interest us when we are considering foreign judgments. So over to you then, if there is anything which still interests you for you to know. These are all things which I thought you should know. This could be something which is beyond what merely the CPC tells you. Thank you.
Okay. Thank you very, very much. And before we throw the floor open for questions, if any, we were thinking of having a session on custody. You've effectively destroyed that.
There's so much more, Sriram. I'm not destroyed it. In fact, custody are those. I merely took some poor decisions. A lot of them. Sure.
Okay, and when we thought of this topic, the basic idea was number one, as you know, my wife and my mother-in-law are in the family court, and
they're experts. In fact, I put this through your mother-in-law and wife to know whether I've said what was essential or whether I've stated correctly. These are experts. I would defer to them, to their greater wisdom than what I've said.
No, I can probably very confidently and proudly say that I am the only person who can confidently say that I go every day to the family court to see my wife. Okay, this thing about foreign judgments and the applicability here, S.R. Rajagopal and me fought a case about it in 2008-2009. Before the single judge, S.R. Rajagopal appeared and I appeared in the appeal which he filed. He was led by Bharat Raman and I was led by the one and only Vedantam Srinivasan. Ultimately, the matter was settled, but that's when we really learnt about Section 13 and Section 44. Unbelievably interesting. But the small twist here was the reference to matrimonial issues, which is become very, very relevant because by the time you file a case here, the husband comes and says, I've gone to Las Vegas day before yesterday and I've got a divorce yesterday. They are called the Reno divorces. And so we thought we would have one session on that, and thank you so much for that. And the automatic fallout of all these proceedings that are filed in the US or in any other country are these anti-suit injunctions. I'm sure we'll have another session for that, because that's a really big subject. And questions, if any. There was one a lady called Gomati, who's incidentally a professor of law at Shastra University. So she knows more than you and me put together. So she's waiting to roast you over the grills. Gomati, please, if she's available.
She's here, sir. She's here.
Yeah.
Don't threaten me like this. I need to put up some face here.
Gomati ma'am, you can ask your question.
Good evening, sir.
Good evening.
Lordship, it was just an enlightened session. And you have explained, Lordship?
Yeah, no lordship. Just say that. I'm not.
Yes, sir. Am I audible?
Sir, Kannan,
Yeah. Am I audible, Lordship?
You are, sure you are.
Yeah, I was practicing law in the Tanjore District Court, and at present I am assistant professor of Shastra University School of Law. So my question to you is, what is meant by illegal degree? Illegal degree. Is there any term called illegal degree?
Why should there not be a decree? By illegal decree is that decree which is passed without jurisdiction, which it could not have done, which is not valid. You want the same expressions of unlawful and illegality. We all understand the differences. So I would only think in a context, the illegal decree must be understood as a decree without jurisdiction. It's not a correct expression. We don't say illegal decree. Anything which is done by a court is not illegal. But at least I know of some case, I can tell you an illustration of what I have seen of a person who was in South Africa. It's another person in Botswana. These are persons of Indian origin. And the husband had gone to Botswana and secured a decree for
yes, Lord.
Winding up the company of what the husband and wife had together in Botswana registered. And the same court had also granted a decree for divorce. This is surprising that a court exercising company law jurisdiction, you don't know what kind of understanding for the judge to have also granted a decree for divorce. So therefore, when the point came to me, I said, no, this is clearly ununderstandable. Please check up with the council there in South Africa whether this kind of a decree was possible. The person, in no part of the world is it possible that a corporate court also passes a decree like that. But then it still gets to be happening. You don't know. I'm not saying Botswana is not a country which can't deliver good judgment, but you don't know what kind of a thing happens, how it ever got to happen. So therefore, that understanding probably that would be illegal. But I would think
yes, Lord.
We don't use that kind of pejorative expression when we're talking about decrees of court.
I've just come across a judgment which used a term called illegal decree. That's what I was baffled to know the definitions.
So it's a euphemism for a court without jurisdiction.
Yes, Lordship. The last question: what is is there any subtle difference between the recognition and enforcement of a foreign judgment? Recognition.
Unless you recognize, you don't enforce it. Can you? So therefore,
yes, Lordship.
They are one to another linked. So therefore, you recognize that tenability of the judgment and therefore enforce it. So see that there is a nexus drawn this way, but you'll again put it through a test of why it can't be enforced. Does it come within any of those exceptions of what you find in section 13?
13.
That's what will be the deciding criteria.
Yes, Lordship. Thank you. That's it, Lordship.
Right, Gomati.
Thank you so much, Lordship.
Okay, thank you very much, Gomati.
Yes,
incidentally, Justice Kannan, yesterday or day before when I was talking to Vaidya Subramaniam of Shastra, so and I told him that you were doing this topic, and he said family law is a subject for them for second year, and he said your speech is going to be one of their question papers. I said, very good. Do you want it live or otherwise? He said, no, don't leak out the question paper, because he's not only going to be the syllabus, he's going to be the question paper himself.
You're leaked out now, Sriram. Anyone who knows, who can pass that information, then you already made that leak. I've been there to Shastra.
I know, he told me.
I addressed the students there.
Yeah, he told me. The next person who wants to ask you something is Bhagya Lakshmi. Bhagya, are you there?
Give a small window of Bhagya somewhere for me so that I know who is the person.
Yeah, Bhagya, switch on your video.
If she doesn't want to.
Yeah, one second.
Yeah, please. No, Bhagya is my classmate, so she cannot get off. Yeah.
You see me now?
Yeah, no, not yet.
Sir, can you hear me, sir?
Oh, yeah. Sure. Go ahead.
Is the video not happening?
It's okay, Bhagya. Go ahead.
Good evening, sir. Thank you for your wonderful explanation of the subject, sir. I have a short question only. It is on that Narayana Rao Venkata Lakshmi. Yes, sir. It says, yes, sir, Narasimha Rao Venkata Lakshmi case, where the woman can state that she is not submitting herself to the jurisdiction of the court. I mean a foreign court. So
it was possible for her. See, what she was able to do is, this is a case where she was domiciled in India at the time when she approached the court. And the husband had already filed a decree for divorce in Louisiana. And they were living together. They were originally there in Missouri. And he had gone to yet another place, lived there for about 60 days or 90 days, and then invoked the jurisdiction, obtained a decree, then got married to yet another person. She was taking action here in India, independently, knowing that there was a case. She was also there before the court. And then later she came here and said, this is a decree obtained by fraud. This is, he is now creating a jurisdiction in the court which did not have jurisdiction. The court didn't see anything. In uncontested matters, it just goes about and then passes an order. Where does it go and find whether the person was actually domiciled there? Who is the other person where they also domiciled? So it was possible for that. And that was the time when the Supreme Court expressed that we have sadly, we don't have so many of the private international law principles ingrained in our statutes. We are looking merely to the common law principles for its understanding. We need a law, a standalone legislation, or we need all the matrimonial issues relating to custody, to marriage, validity, all of them to be brought through our legislation like the Special Marriage Act or Hindu Marriage Act. They were finding inadequacies of our Indian legal system and the laws which were there. They applied the private international law principles, and then made it possible for this lady who had been married only in India at Tirupati to secure that decree which was passed elsewhere was not enforceable, was not valid, and she was entitled to take action for bigamy against her husband.
My question again here is, there is an ambiguity in that judgment according to me or my understanding. What I feel is, when I say that I'm not submitting to the jurisdiction of the court, does that mean I will have to file it as a petition with the grounds, or does that mean that is I'm submitting saying that I'm not submitting to the court? How does that go? I file it as a paper to the court and saying that I'm not submitting to the jurisdiction of this court. How is that valid when it comes to India? In case if it is a present case.
Yeah, I understood now. See, a person can't choose not to be appearing unless that choice is a valid choice. Think, for instance, there is a case filed in Madras High Court, and the defendant does not want to appear, and then stays in Delhi and says, I will not subject to the jurisdiction of Madras, I don't like Madras. It doesn't work like that. You have to submit. But if a person can bring about a refusal to submit to jurisdiction, it must be legally founded as possible. In this case for this lady, it was possible for us to say that it was a case where she had actually appeared at some point of time, and later she came away and said, I will not be bound. She was there at the time. She was a US citizen, and both of them were working there in USA, obtained the foreign citizenship. Later she had come to India and she had been domiciled here, and therefore she said, now this person has gone to a court which had no jurisdiction. Therefore, I am not bound to submit to jurisdiction, because this foreign decrees, unlike a case of res judicata, where even a wrong judgment could be binding, with reference to your foreign judgment, you will be independently competent to come with another suit. I did not submit to jurisdiction because my choice was based on the fact that the court which was passing an order had no competence at all to pass that order. It was possible. Unless you're going to be contending that you can bring within any of the exceptions which Section 13 provides, you will not be entitled to say, I will not submit to jurisdiction. Submission to jurisdiction can't be merely your choice, the way you like it. It must be founded on a legal principle. That is the way I would like to see that she chose to remain in India. It became possible for her to say that there was something. Supposing this case had been filed in Missouri itself, and both of them were residents there at the place, and he had filed a case, she had appeared before the court. Later, she decided not to go to the court. Can she say, no, I refuse to submit to jurisdiction, I am domiciled in India, and therefore it is valid? Here, in this case, in Nasimara, the court was able to see that the decree was bad. The competence of the court which passed the decree was not valid. And they were able to invoke under Section 13B and D. One was fraud, another was without competence. So they found that there was some flaw there, and therefore said the decree will not bind. And therefore she is entitled to initiate action. Otherwise, she couldn't have succeeded. She will be bound. Let us not advise any persons. You come away to India, any decree which is getting passed there in the USA or UK is not going to bind you. No, it will not. Because I already told you, of courts of competent jurisdiction where reciprocating countries, their jurisdiction and decisions will be binding. Matrimonial matters also will bind, but we'll have to see that these exceptional situations arise.
So, if I frame it this way, will it be right, sir, that if I am going to go for a forum shopping, then the situation should be just that it falls under any of these conditions under Section 13. Then forum shopping is allowed.
Don't use that at all. In fact, it's always used in a pejorative sense. Forum shopping is sharp practice. I would therefore, I'll go to this forum. This forum shopping is to be always used in a negative sense. It's therefore, can I forum shop elsewhere? No, you can't. You can't do forum shopping at any place is what you should start with your understanding. Then later say, is it possible for you to go to another court because that court which passes that order or a decree did not have competence, and therefore you'll be able to bring your case within any of these exceptions of what Section 13 brings out. If you are entitled to do that, then you'll be able to choose for a forum outside the foreign jurisdiction and come to India to have an independent decree. So therefore, number one, there will be no forum shopping in any situation. Two, if you are choosing for a forum in India and not deciding not to contest elsewhere, it is because you are sure about any of the exceptional situations what Section 13 fundamentals.
Thank you so much for the detailed explanation, sir.
Thank you.
Yeah. Next, we have Jayaprakash. JP.
Sir, good evening.
JP,
I'm so sorry.
Switch on your video.
Yeah, my bandwidth is too low to have the video.
That's okay.
So what is the effect of an ex parte orders are obtained abroad? One party is here, the other party is abroad. Unfortunately, if the person doesn't have the copy of the order, can he file a separation here afresh and get a decree from our court, or is it necessary to do that?
See, there are two decisions which have come out like this. Under Section 13, the decision not on merits. We have provision here under Order 9, Rule 13, Order 9, Rule 9. A decree which is ex parte it will not be the principle of res judicata. It will be a principle of estoppel which will operate. I'm sure there are judgments which you'll know. Same way, a decree which is passed, which is ex parte in a foreign jurisdiction, will still be valid. It is not as if it's not a case decided on merits. It will be a case which will be where you'll be estopped from pleading otherwise. So therefore, that is one thing. In my recollection is in one of these judgments of what I had given, in one of in Sankara Koundan, I think, was a case where they were referring to they were saying this judgment is merely a photocopy which is filed. They were saying photocopy or no photocopy. Now, if you have at the time when the matter came to Supreme Court, they're saying now, is it authentic? Is it the same kind of order? They had manner of knowing that the order had been passed, no matter it was photostat, photocopy. So they said photocopy of even a foreign judgment, if it is otherwise known to be authentic, it is fine. Therefore, it is acceptable, is what they said. So you did not obtain a certified copy. In these days of communication technology, was what is not possible. In any country, you will be able to access the particular court. Sitting here, I'll be able to access what is happening there in New York and secure an order copy if I want, if I'm involved there. You'll have to go through a process, that is all. So therefore, to know about authenticity is not a big deal. Supreme Court has held in one of the judgments which I've stated, it could be like what I said, it could be Sankara County, where they were saying photocopy is also fine. So that is the way I look at it. Ex parte is still a decree. It will not be taken as not a decree on merits. It is still a decree which will bind you, stop you, unless you can bring the case within 13.
Thank you, sir. Thank you very much.
Yeah, Jake.
Okay.
We have one other person, sir.
No, I think we might have one more. SPRT. These are all the regular practitioners at the family court. I'm sure they'll have far more.
We have one other person, sir. Thirumalai Kumar.
Okay, he can ask. Let's
I'll wait, sir.
see if Aarti has something to ask.
Yeah, Aarti.
Good evening, sir. So thank you for the enlightening session, sir. My question may be a little late.
Aarti, where's your video?
Sir, COVID appearance, nothing great. So.
Okay.
It's okay.
Are you trying to say that you've aged?
That's okay, Aarti. Go ahead.
Yes, sir. Sir, assuming I contest a case abroad, be it a civil suit or hello? So
I'm hearing you.
Yeah.
Be it a civil suit or a matrimonial dispute, I contest it. Can I still come back and plead in India, in assuming it's a country which is not a reciprocating country, stating that the decree does not fall, is not conclusive judgment because Section 13 is still hit?
Yeah, it's in a judgment in the year. I tell you recently of what has been passed by Justice Ramanna. He was referring to the issue of a decree, whether it is binding. This decision was it? This is the decision in Alcon Electronics in 2017, 2 SEC page 253. It was the infringement of patent case. This is a case where the person went and entered a contest. You were asking about what do you do when you enter a contest in
Yes, sir.
he entered a contest, not on all issues. He entered a contest on the issue of reference to cost. And he came to India and said that the patent issue of what is violation, it is not violation here, it is something wrong, it is not valid. The court was not prepared to see it at all. Justice Ramanna says in 2017, now you submitted to jurisdiction what you had a right to say there, you should have stated there. You go there and do whatever you want, but you won't be able to reopen things here and say that this decree will not bind. I'm afraid that's what will happen. If you have a case there, you make a contest, you have it full-fledged, and then you come back here to India and invoke 13. Just me, in a situation like that, what Section 13 will make possible for you to enter a contest? Tell me that it is not a judgment on merits. No, you won't be able to say that because you enter a contest and therefore a case is decided on merits. And the person is without jurisdiction, issue of jurisdiction, you must have taken there in a point of contest, which you should have taken there and taken. Does it offend the principle of international law? You put it through each one of them, you may not be able to succeed there, because when you are saying you're entering a contest, I understood that you're entering a contest on merits, not entering contest because like you drove a Mercedes car which the parties gave. It's not even that. That is a decision which our court says, the Supreme Court says, the issue of bias could be completely, could vitiate a judgment. It's possible. Vishwanathan says that, case from Mysore in Madras High Court went to Supreme Court. They said it is a relevant point for consideration. The point that Mysore judgment stood was a different thing, but they said it is possible for you to take that contest. So unless you are able to show that the judgment which is rendered in spite of your contest suffers from a very serious vice of what you could not take at that time, or what you did not know existed at that time, which came to be known later to you in India when you are coming, then you are able to take the point. Otherwise, I would
But my contest would be very preliminary even on the issue of jurisdiction of the foreign courts.
I said to you, therefore, right of contest, invariably, do we not say, even in the civil procedure code, look at the principle, you'll have to be taking an issue of jurisdiction at the first,
Yes, sir. Yes, sir. The foreign
country,
I'm sorry, sir. The foreign country may assume jurisdiction, but as per Indian law, it still may not have jurisdiction. So can I come
I don't know, test me on what you have to say on the issue of jurisdiction. Unless you're going to be saying like what I said in Botswana, South Africa, a court patently did not have jurisdiction, it still did that. It passed an order like that. Okay. But otherwise, in a situation where you enter a contest and that contest allowed you the benefit of saying that court did not have jurisdiction. Or if you're going to be saying that court had jurisdiction in that country, in our country, it will not do. That's why I told you of a ground of a marriage, of irretrievable breakdown of marriage, which the Indian Hindu Marriage Act does not contemplate. The Law Commission recommendation is still there, not there. In that country, if an irretrievable breakdown of marriage, you would have entered a contest, or irretrievable breakdown, you say there is no such breakdown, and the court says no, it's still a breakdown, and then the court grants a divorce. You come back to this country, this decree is not binding because that is not a ground which is available in India. You may not be able to say that. I already took that issue. Whatever is something which is possible here in India was not possible there, and therefore the decree is not binding, is not what the law allows you. The law allows you a very close window through 13. 13 is not very expansive. Don't think they are very expansive. They are very well understood through judgments, each one of them. So therefore, each one of those grounds, you have fairly a good background to understand. I would like to think in the way Justice Ramana has approached in a recent case where a contest was there only an issue of cost and not all other matters. And they said, no, I'm not open. We are not opening anything. Go there and then say anything. We are concluding the issue with reference to the binding nature. That's how they've looked at it in 2017.
Thank you, sir. Thank you very much.
Yeah, there is a Prabhavati wanting to say something.
Mr. Thirumalai.
Good evening, sir.
Good evening.
Yes, sir. Thank you for your enlightening lecture, sir. I am Prabhavati, faculty of School of Law, Shastra University, sir. Only one question, sir. Shall I ask, sir?
Tell me, please.
Yes, sir. Sir, at present, most of the judgments comes in favor of the live-in relationship, sir. What is their opinion which relates?
All right. There's no opinion beyond what the law states. Section 26 of the Protection of Women Against Domestic Violence says the provisions of that act will be applicable in any situation, in any defense. It's not necessary that any application must be filed under Protection of Women Against Domestic Violence. You have a theory of incorporation brought in the legislation itself. So therefore, that law recognizes live-in relationship. You know also the unusual expression which Justice Kajju made.
Yes,
Justice Kajju is always unusual expressions he's entitled to make, and he will always make. In one case, he said, which went from our court, he said one night stand. Now these kind of expressions can't bring live-in relationship. Yeah, live-in relationship is that relationship which has some kind of a consistency of those persons living together, not as husband and wife, but they had it was just not one-off relationship for a night. They had something more in their mind, and they could have, for the purpose of that act, and to any other provision you'll be able to take. And there are very interesting decisions from Bombay with reference to sharing of household in a case where the person in live-in relationship will the person be entitled to, where there was a case where, I'm not able to give you a citation, but look for it, you'll get it. Both husband and wife independently purchased property. The husband property which was purchased in the joint names was a larger house. The property which was purchased only in the name of the husband was a small property. The wife, the woman in live-in relationship, she was there in the larger house which they jointly purchased, and the man went out of the house, and she said she's entitled to retain custody of that large house. It was a shared household she is entitled to stay in that house and she need not to go to each other place. The court accepted that and said the status of parties in a live-in relationship is that she is entitled to a shared household. And this was the place where they were jointly living together, and therefore she is entitled to stay there. So what is my, what do I think about live-in relationship? I think world over it's happening. Marriage has been probably the longest institution of which survived over centuries. That bond of a man to a woman, it's always intense, and to allow for the next generation, a civilizational advancement takes place through the institution of marriage for protected children, for children who are passed on the good values from one generation to another. So therefore, societies, they believed that this morality, that for civilizational advantages, it is necessary to protect the institution of marriage. And therefore, all countries provided some system of registering of marriage or bringing a legitimacy. It has taken place in various ways. There have been in some of the islands, they make it as great fun to have a marriage there, and they make provision for registration. There are islands which have nothing except a registrar's office where a marriage register is taken. Even in all the countries where with the promiscuous relationships, still the marriage, for if I may take an example of Tiger Woods, was such a popular man. He was a world-renowned golfer, and another relationship with a woman with whom he was driving and had an accident, the marriage collapsed. It's not possible for a woman to accept that a man could go with another person. It just won't be accepted. That is what is life. And therefore, while saying all that, but it should go through a system of marriage. Would it always be there? I'm not too sure, because even in India, people are looking at it very differently. If they won't want to complicate things through institution. There is a beautiful thing in the Netflix. If you want to see, you may see. There is a Little Things or something, Half Little Things or something. It's about a man and woman in a relationship in Mumbai. And the man moves away, the girl as an architect, she goes away to France. And the torment of what they suffer when it comes to a separation there, of what one believes he has a control over her, or where she believes that she doesn't want to lose him, even if the marriage is not taking place. So that societies, I don't think they've all come to uniform understanding that without marriage, they can all be living together. May happen because in UK, 1 in 3 marriages fail. So therefore, the failure rate is so high, they don't want to go through a form of marriage. They would rather live together, and if it goes out, it goes out. You don't end up paying big settlements. India, therefore, protects that also. You come to live together, you'll still be liable to maintain. You'll still be economically, whoever is strong, you'll be able to provide the benefit, or they may have to share a household. I think it's a very progressive legislation of what India has brought in to protect family relationships.
Yes.
That's my take, Prabhavati.
Before somebody else, thank you, Prabhavati. Before somebody else comes in with a question, I have a question for the first time in the last 5 sessions.
Yeah, Shriram, you are challenging me at all times.
No, I will definitely not challenge you. Prabhavati asked you about live-in relationships and what is your opinion about that. And you gave a very, very politically correct answer initially, and then you sort of explained. I'm just asking you in a very, very light vein. Suppose this were 25, 35 years ago, would your answer be different?
It would have been different. 25, 30 years back, I couldn't have even thought of a live-in relationship as possible for a person to have the claim as a spouse on the other. What are we now talking about, Shriram? When we are talking about same-sex marriages, what are we talking about? Why are countries thinking of bringing about legislation to approve of same-sex? If being an adult consensual sex between persons of the same sex is possible, and our law also has progressed in that sense, why do countries talk about bringing a legislation for marriages? Why is there a craze for the registration? It can still be merely a live-in relationship between a man and a man and a woman and a woman. Why are they talking about registration of marriages? Why are they talking about it? Because they want to assure in the orderly succession of properties, in the orderly advancement of the civilization from one generation to another, some kind of a seal is essential. So therefore, for me, this institution will not easily go. We will probably be employing euphemisms. You may say this marriage, after all, it's a marriage. There you go to a registrar's office, you register. Here you have not registered, but they live together. That living together is still an important thing. You have understanding. It's just not one or two casual relationship or sex. It's beyond that, what a person wants to live with the other. So therefore, we have moved in the direction, but we have not come too far away from the fundamental principle. I now understand and accept it because that is the way the law is moved. But seeing that there is a push for same-sex marriages, I get again doubtful about the live-in relationships. They could have still persisted with live-in relationships only without marriages for same-sex people also. But they believe property rights are such an important thing. And therefore, they think marriages must be done. The Supreme Court in USA, when they were approving in 2015 same-sex marriages, imagine that was a court packed with just a 5-4. That is the difference. And they just scraped through, kind of. And it was because they understood that is the reality, that registration or some form of marriage becomes necessary. You employ euphemism and say that this live-in relationship. It's accepted for me. It's acceptable for me now because it's accepted world over, and therefore, perhaps if I'm the first person to make a decision, I may not have been so progressive to accept that without registration, marriages should still be legitimate.
Yeah, and there are too many people watching, so it's acceptable to me as well. So let's let's have Thirumalai Kumaran with his question. I'm sorry, Thirumalai.
Okay,
Yeah,
okay, no.
Yeah.
Good evening, Lordship.
Yeah, Thirumalai.
Lordship has elaborately.
Kannan. Call me Kannan, sir. So you don't call me Lordship. It's a little embarrassing for me.
Yes, elaborated the theory of a community of nations. Now, all of us know that post 1990, most of the countries, including us, are signatories and parties to the GATT, General Agreement on Trade and Tariff. What is the, I want to know, what is the relevance and the importance of the provisions of GATT in dealing with different judgments?
GATT.
General Agreement on Trade and Tariff.
So what has it to do with what?
What is the relevance and the importance of the provisions of GATT in dealing with the foreign judgments?
In dealing with foreign judgments?
Yes.
See, we are talking about in GATT. See, we are probably the trade agreement that was essential, was in a changed world of making the kind of cooperative endeavor in the matters of trade and commerce. It recognizes that and still wants to protect in some ways both the product and process like patent. And India at all times resisted the idea of a product patent. We were going on reverse engineering many of the pharmaceutical products for us. It was possible for us to create, take a foreign product and do. Now, not any longer possible. GATT, therefore, gave a whole understanding. All of us must come on equal platform. We'll recognize invention of one country to another. That's where probably GATT for me had an important understanding, an important impact of how in the international trade we would recognize countries' inventions and where we will allow for free exchanges. You will not have any privilege in relation to duties. You will not give any favor to another. There will be a free movement. A world without borders is an attempt through GATT with still some protection for inventions. This is how I see. A committee of nations, we are talking about several other things. We are talking in GATT only a particular area of activity of trade and commerce. In a concept like Committee of Nations will take in also the concepts of what you have in GATT. But you have several other subjects which you're seeing in Committee of Nations. In our relationships with one country to another, we need to recognize the sovereignty of yet another country, the need to have their own forums and institutions of justice which will work for the people who are domiciled in that country. So you have several concepts. Who obtains an order, where it is executed, should it be executed? should that country have some prescribed limitations for enforceability elsewhere? This is how we are seeing. In many of the recent conventions, UN conventions at about all times been attempting to bridge the countries beyond borders. And there are endeavors which it makes. The recent Singapore Convention, to which India was a party, which I made a reference about, was in the area of all subjects other than matrimonial and succession matters can still be matters of commerce. It can still be a settlement which takes place outside India, could be enforced in India. India must also recognize that and give its enforceability through appropriate domestic legislation. That's what the convention says. So therefore, it is on a principle. It is also in a committee of nations. We all want to recognize. I use an expression which judgment of the Supreme Court says. We defer to a judgment of a foreign country and not obligated to do that from a foreign country. That's what they say. So therefore, you understand.
And here it is Jwala.
Hey, what happened to the speaker?
I don't know, sir. I just.
Okay.
It's disconnected, I guess.
No, I am audible.
No, you're audible, but we want to know the others. The gentleman who was responding to you. We're not able to see him or hear him. So please hold on for a minute.
Next one it is Kavi.
Kalpana Ranganathan, you'll have to wait till such time Thirumalai Kumaran finishes. I'm sorry, if you want to ask a question. Is that okay?
Is Kavi available?
Yes, sir.
Oh.
Sorry?
Yeah, this is
Okay, sir.
Okay, right.
You have to substitute the values. In the formula, again, why you are telling the same thing? Next one here, this is Kirtana. Tell me now. What is the next one we are supposed to write? Yes, tell me. I could hear you. Please tell me. Now, next one here. This is for Madhumita.
Wilson, I'll just call him.
Very good.
Shriram, I don't know why I'm not there, Shriram. I've come. Yeah, I'm seeing myself. I'm seeing myself there on my screen. I don't know why you are all not seen. I don't know what has gone wrong.
You'll have to unmute. You're now seen. You'll have to unmute yourself.
Yeah, I've unmuted myself, Shriram.
Okay, great. We can hear you.
You muted for me.
Wilson, is he audible? No.
I'm able to see myself. I'm seeing that there is no mute button there for me.
There should be a mute button for you.
You're not hearing me, Shriram?
No, I'm able to hear you. Okay, why don't you just continue with answering Namma Thirumalai's query?
Enna query theriyala na ketala enna theriyala.
Thirumalai was asking you about how...
No, I answered, Sriram. That's all. I don't know. I didn't realize that I was not in the air at the time when I was responding. I said GATT gives some issues relating to international trade and commerce on an equal platform with making possible access of goods and services to be used with any other country without any trade barriers. And the barrier it places is to protect certain issues of patent and inventions, protecting inventions. When we are talking about Committee of Nations, it is to advance that state. But beyond trade and commerce, or what GATT talks about, we are looking at so many other things when we are talking about Committee of Nations. This is what I said.
Okay, right. Thank you. Last question probably for the evening is from Kalpana. Kalpana Ranganathan, correct?
Yes, ma'am.
Yeah.
Yes. Once again.
Yeah, that's okay. Kalpana.
Yes, it's audible, sir. Good
Yeah.
evening, sir. Good evening, sir.
I don't think so. The speaker is.
Sir, it's audible.
Just hold on. I think there's something wrong at his end as far as connectivity is concerned.
No problem. Thank you, sir. No problem, sir.
Okay. I think Wilson, has he gone off by himself or?
No, sir. No, sir. He's with us. I guess he has trouble hearing us.
Oh, really?
Kannan, sir, can you hear us? I think. Hello.
I don't think he's there.
I can see him, sir.
You can?
Yes.
Can you hear us?
Once again. Oh, it's.
Uma, you can see him, is it?
Hello.
Uma,
I was able to see him on the second screen. Now he is gone. It's become blank. I saw him this moment when you were saying.
Okay.
Whether he's there or not, he was very much there. Where I think Wilson also said he was able to see him at that point.
I don't know. I don't know what's happening. I think this might be the only time where we might have to give a vote of thanks in the absence of the speaker.
Yeah. And it also crossed the time today. I mean, it's quite a lengthy session.
Amma, iva enga namma Bhagya.
Sir, I think we.
அடுத்த 2-3 family court cases க்கு வந்து she's taken an opinion from him. இது மாதிரிலாம் பண்ணா?
Sir,
free opinion and guidance.
His connection is. We have lost his connection, sir.
Lost it?
Yes, sir.
It's a general question from my end.
சரி போதும்மா.
Anyway, thanks a lot. It's very nice.
No problem, Prabha. So I think we'll call it quits with now. We're unable to establish contact with him.
Okay.
So if any of you have any specific questions, and you received a confirmation of registration, adula vandu one email ID is there. Post your questions to that. We will forward it to Justice Kannan and probably he will respond to you.
Answer and respond.
Yeah, if you have any specific questions, please. But Bhagya, you will be charged. I accept Visa and MasterCard. Okay. Okay.
Sir, Kannan sir is there. Oh.
Is there?
I don't know. I just saw him for a minute.
He's there. Is there
I think he has to unmute himself.
So anyway, we will have to say thanks to him in private.
Sure.
No other way out. So I hope all of you enjoyed it, especially the people who are practicing in the family courts, because this is probably slightly more important to you. Though the importance of foreign judgments and the enforceability and recognition and enforceability thereof is also one nimsham. Hello. Hello. Atha, we are not able to see you or hear you. I'm just telling all these people that the first time in the history of the world, the vote of thanks is being given without the speaker being present. Huh? Sorry, now Mudichita, I'll call you. Okay, thanks. Right, thanks. Right, right. That was him. Oh, you're now there. Yeah, we can see you. Can you hear me?
That's his problem, sir. He's getting disconnected often. I think.
I can see him, but I don't know whether he's able to hear me.
Wi-Fi something. He's got
Like
network issues.
He's having network issues, obviously.
Oh yes.
So like Sri Charan texted me a question or an observation. This question of foreign judgments is also very, very relevant nowadays with cross-border agreements and transactions, international transactions between companies which are either based or headquartered in India and companies that are outside the territory of India. So in all these circumstances, foreign judgments and their recognition and enforceability becomes a real issue. And therefore, we thought we would come up with this topic, and that's why we called Justice Kannan to, come and have a chat with us. And with his ability to draw parallels and to ensure that the latest law is also brought to your notice, our notice, etc. If we have gained something by his lecture and interaction with us today, we're very happy. And so thank you very much for being patient, because it's been almost 2 hours now. And tomorrow we're having Balaji, PB Balaji, advocate on summary suits. So those of you who are basically into trial work and those of you who appear in the high courts also in respect of the original side, Order 37 CPC, which might interest even the government leader, CS. Please do join us. We'll send you the invitation. And day after tomorrow, we have Justice M. Sundar speaking on an overview of arbitration law. So we hope that you've enjoyed watching all this, because for us, it's not just a topic on which a lecture is given. For us, it's also a question of you should be able to enjoy yourself, whether it's a law topic or otherwise. That's why the informal atmosphere. Of course, on certain days, the informal atmosphere might reduce slightly. That cannot be helped. But I hope you've enjoyed watching and hearing Justice Kannan speak today. And Thank you very much. Thank you very much.